Okay, the Illinois State Constitution continued. I hope this is helping you. Illinoisians and we the people and those that live among them, especially your diplomats, paperless or paperful. Exclusion of illegally obtained evidence. The U.S. Supreme Court decisions beginning in 1961, evidence obtained in violation of the Fourth Amendment may not be admitted in state courts against the persons whose rights were violated. The Illinois Supreme Court has applied the same rule since 1923. The basic purpose of the Fourth Amendment. When you hear dates, you've got to think who was living during that time, especially what emperor or empress or king or queen, because they help you in ways that elected officials never will, and they help you in ways that even those that are like aristocrats aren't able to. I'm going to keep my secrets to myself. That's for you to goddamn figure out. But anyways, the Illinois Supreme Court has applied the same rules since 1923. The basic purpose of the Fourth Amendment in this section is to prevent indiscriminate searches of private homes and possessions. Searches and seizures are to be limited to situations in which either an immediate search is required, such as the arrest of a person who might have concealed weapon, or to the police have probable cause to believe a crime has been committed and can persuade a judge to issue a warrant to search a particular place and seize a particular person or thing. Number one, that's against the federal Constitution. Now, if it said concealed like bomb, an explosive thing, yeah, that they're going to blow up some federal or state or some other one's home, yes. But not to invade someone's home just because they have weapons. Yeah, Shane Tyler Propert Sr. did that in February of 2019. And the police stood with him. He broke into the home that he had left and stole out all of the weapons. Okay, because this so-called exclusionary rule for unconstitutionally taken evidence is designed to discourage police from violating the rights of the innocent rather than to protect the guilty. The U.S. Supreme Court has fashioned a good faith exemption to it. This exemption says, in essence, that if the police officers believe in good faith that what they were doing would be held constitutional, evidence they collect should not be barred. One or two Illinois decisions, both by appellate court panels, have endorsed such an exception to the exclusionary rule. Invasion of privacy and eavesdropping. As with the prohibition against unreasonable searches and seizures, this section protection of privacy applies to government actions, not actions by private persons. Which means, I guess, that we can eavesdrop on our conversations with the government, and wiretap our own home. So that when the CPS or sheriffs or police or state troopers come and want to be pains in the ass to a private citizen who's behaving themselves under good law, yeah, we can video record them. As with the prohibition against unreasonable searches and seizures, this section protection of privacy applies to government actions, not actions by private persons. The Bill of Rights Committee at the 1970 Constitutional Convention, which proposed this provision, said it was intended to guarantee each person a zone of privacy in which his thoughts and highly personal behavior are not subject to disclosure or review. Let me read that again, because the satanic Nazis of the fam and society, have brainwashed most of you not to understand this. I'm going to read that again. The Bill of Rights Committee at the 1970 Constitutional Convention, which proposed this provision, said it was intended to guarantee each person a zone of privacy in which his thoughts and highly personal behavior are not subject to disclosure or review. But rather than proposing a total ban on interception of communications by government, the committee and the full convention decided to prohibit unreasonable interceptions. They specifically said that interception of a conversation for law enforcement purposes with the consent of the state's attorney and one party to the conversation and approval of a judge as provided by law would not be prohibited. This constitutional section has been held not to invalidate the law. Illinois courts have held that it is illegal for police, without complying with that law and with the consent of only one party to a phone conversation, to listen in using an extension telephone of its microphone is disconnected. But if a hand is held over the microphone to muffle sounds from the listener. This section did not invalidate the Illinois Government Ethics Act or a governor's executive order requiring financial disclosure from various state officials and employees. You can go online and read this yourself. Out loud really does help. Section 7, indictment and preliminary hearing. No person shall be held to answer for a criminal offense unless on indictment of a grand jury, except in cases in which the punishment is by fine or imprisonment other than in the penitentiary, in cases of impeachment, and in cases arising in the militia when the actual service in time of war or public danger. The General Assembly by law may abolish the grand jury and further limit its use. No person shall be held to answer for a crime punishable by death or imprisonment in the penitentiary unless either the initial charge has been brought by indictment of a grand jury or the person has been given a prompt preliminary hearing to establish probable cause. This section allows abolition of the use of grand jury indictment in criminal cases and provides for a prompt preliminary hearing as an alternative. Grand jury indictment. A person cannot be held for a serious crime without a grand jury indictment, except to the extent that use of grand juries is limited or abolished by law. In 1975, the General Assembly did not limit their use, providing that prosecution for any crime may be begun without a grand jury. In felony cases, a prosecution may be begun by the prosecutors filing in court of an information, a sworn statement stating forth causes to believe that a person has committed a crime. In less serious cases, a prosecution may be begun by either information or complaint. But prosecutors still choose to use grand juries in some cases, particularly those that are controversial or need the investigatory power of a grand jury. The requirement in the U.S. Constitution's Fifth Amendment of grand jury indictment for serious crimes does not apply to states. May God and ourselves give us discernment. Amen.